The most painful sentence I have ever handed down was not because the case was complicated, but because the law could not give anyone true justice. I am Angela Thompson, a judge in Atlanta, and I want to tell you how in a trial that seemed routine, I ended up facing a dilemma that changed me forever. Before we begin, let me know in the comments where you are watching this video from so I can see how far it has reached. It all started with a domestic violence case, one of those where the law has clear rules. The accused, a man named Marco, had assaulted his wife, Elena. It wasn't the first time, but this time was worse. The law demanded a strict sentence, and as a judge, I had to apply it. But there was the problem. Elena asked me for something that wasn't in any judicial manual, that Marco be given a second chance, that he receive help instead of going to prison. I faced that and asked myself, how can I punish someone knowing that deep down both lives are broken and need more than a sentence? The law was clear, but would that be fair? For Elena, for Marco, for their child? As the evidence piled up, I heard testimonies, looked at documents, and in the courtroom something bigger was forming, a conflict between being strict with the law and being humane with reality. Marco was not a monster, nor was Elena a victim without fault or dignity. The law did not consider that these cases have nuances, stories between the lines, and lives that, with imprisonment, could be irreparably destroyed. When the time came to hand down the sentence, I felt in my hands not just papers and a seal, but decisions that would mark lives forever. I weighed the regulations, the penal code, the recommendations, but also Elena's tears, the child's uncertainty, and the possibility that Marco might change or be ruined forever. I decided to impose the minimum penalty allowed, but I also ordered a mandatory rehabilitation program and family therapy, something not in the law, but that I know can save lives. It was like walking a tightrope between the legal and the human, the just and the necessary. After the sentence, something inside me was never the same. I realized that abiding by the law is an obligation, but being just goes beyond it. Sometimes, the code that I firmly hold in the courtroom falls short in the face of the complexities of human beings. I felt that I had done the right thing, but also that it wasn't enough. Neither the law nor my position. Maybe my sentence will never appear in justice books, nor be a landmark jurisprudence case, but for me it was the hardest, because it showed me the gap between the law and real justice. And that gap hurts, and it hurts a lot. So yes, we apply the law, but true justice sometimes requires more than a ruling. Sometimes it requires humanity, understanding, and courage to accept that the law doesn't always reach far enough. Have you ever experienced a situation where the rules don't solve the problem? Tell me below. And don't forget to subscribe for stories no news outlet will tell you. Thank you for joining me. I am Angela Thompson, and this was my most painful sentence. Until next time. I only want the content of the text translated, without any explanation or indication. The sentence had fallen upon the accused with all the force the law allowed, and yet, something inside me refused to accept that it was enough. During the weeks of the trial, every word, every argument, every look exchanged in that courtroom had seeped deep into me. It was easy to pass judgment from a distance, with the papers in hand, following the protocol to the letter. But when I saw that man there, sitting in front of me, with a lost gaze and a pain he could barely conceal, I felt that the law fell short, that the justice I represented was only a shadow of the real suffering behind each case. I remembered how it all began, with that seemingly simple complaint, just another dispute between neighbors that seemed to lead nowhere complicated. However, soon a sea of hidden factors came to light, dark flashes that would never have emerged if we hadn't dug a little deeper. Stories of abandonment, of hidden violence, of desperate decisions that didn't justify the acts, but did demand context, a more humane perspective. And there I was, in the middle of that whirlwind, holding the scales, trying to balance something that seemed impossible. There was a moment during the hearings when a woman came forward as a witness. Her testimony was a confused mixture, a blend of pain and resentment, but also compassion for the accused. She told the truth no one wanted to hear. The man had not always been like this. That life, with all its cruelties, had driven him to extremes he himself had never imagined. At that moment, something inside me broke. What use is a fair sentence if that justice does not recognize the suffering behind the acts? How can the law, which should protect, be so rigid that it forgets empathy? The tension in the room was palpable, not only among those present but inside me as well. I knew I had to sentence according to the law, but during those final deliberations, my mind kept filling with questions that had no easy answers. Would it be fair simply to send that man to serve a sentence without considering the roots of the problem? Without considering how that decision might affect not only him but his family, his community? Without a doubt, it was not an ordinary case. It was a case that deeply challenged me both as a judge and as a person. What no one expected, not even me, was what happened right after the sentence. That night, in my office, while reviewing the documents once more, I received a call that changed the entire perspective of the case. It was a young man, someone connected to the accused, who begged me to review the sentence, saying there were details I didn't know that could completely alter that man's fate. At that moment, I felt the weight of responsibility multiply. Could it be that justice was blind to an even deeper truth? Could I, from my position, do something beyond the paper and protocol? I decided to listen carefully because even though the law is clear, I also had the obligation to be fair, not just legal. Hearing that version forced me to investigate more, to delve deeper where others had set limits. I discovered that behind that life marked by mistakes was a constant attempt at redemption, that the accused had faced harrowing circumstances, and that partly, the lack of support and understanding had been the true executioner. It was a hard blow for me to realize that the law cannot always encompass all human complexity, and that my own task sometimes had to go beyond strict rules. But even with all this new information, I had to act carefully. The sentence was already issued, but this was not the end. It was only another chapter of a much larger story. I began to wonder how I could contribute so that justice would be more than punishment, an opportunity for renewal, for hope. At that moment, I decided to do something uncommon, something that would take me off script. I initiated contact with social support organizations and community groups, seeking alternatives and programs that not only saw the convicted behind the crimes, but the human being with potential for change. It was not easy. I faced criticism, questions from colleagues and superiors who saw my attitude as weakness or professional deviation. But the conviction that justice had to be more humane and complete was stronger than any external pressure. Testimonies, reports, accounts from volunteers and experts began arriving, all agreeing that traditional paths of criminal justice could be insufficient, sometimes even counterproductive. These contributions helped me formulate a follow-up proposal for the case, a model combining punishment with social and psychological support, with the idea not only to punish but to restore. The internal struggle, however, did not disappear. There were days I felt that struggle consumed me, that the scale tipped one way or the other, that the equanimity demanded by my profession and the compassion born from within me walked in opposite directions. But I could not turn back. I had understood something crucial, that true justice is not only the strict application of the law, but the constant search for a balance where both the rules and human dignity are respected. And that, for me, was a revolutionary challenge, a challenge I had to face every day. As the months went by, the case became more than just a judicial file. It was a living story, a tangible reminder of our system's limitations and the urgent need to evolve. The accused, with the support of the programs we managed to implement, began a reintegration process that many considered unlikely. But the most important thing was not only his change, but the transformation that experience produced in me as a judge and, above all, as a person. I learned that behind every sentence there are lives, that sometimes the law must learn to be flexible, and that true justice requires the courage to look beyond the obvious. No system is perfect, that became clear. But we can aspire for justice not only to be correct on paper but alive, sensitive, capable of healing and not just punishing. That case, which at first seemed routine, ended up being the episode that defined my way of administering justice, that taught me that fulfilling the law is not always enough. Sometimes you have to listen more carefully, look more deeply, and act bravely in the gray areas where the rule is insufficient. Now, whenever I look back, I see not just a verdict, but a lesson that has accompanied me forever. I know I cannot change the system alone, but I can be a voice that promotes reflection, that opens new paths, and that keeps alive the hope for a more humane justice. Because in that balance between the law and the heart lies the true meaning of our task. And although that sentence remains the most painful I have ever rendered, it is also the one that has most honored my commitment to justice. Sometimes I wonder what would have happened if at that moment I hadn't heard that second voice, if I had settled for the rigidity of the code. But I know every step in this search has led me to understand that justice, to be just, must be much more than cold logic. It must be an act of humanity that recognizes life's complexity, embraces fragility, and never forgets that behind every sentence there is a beating heart waiting for a chance. And that is the truth I carry with me every day, both as a judge and as a person. What came afterward was not an easy path, nor did it diminish the weight of that sentence I had imposed. But the seed of doubt and the need to humanize justice kept growing inside me, challenging daily the rigidity of the law I was meant to uphold. I received more calls, anonymous messages, reports suggesting that the man had not only made an error, but had also suffered abuse and marginalization since childhood. I encountered contradictory, tangled, and partial information, but with a persistence that forced me not to close the door to new possibilities. That was when I began to investigate not only his past, but also the environment that had shaped him and, in a way, allowed him to fall into the shadows. Finding the truth in that sea of contradictions was not simple. At first, I faced resistance from some colleagues who criticized my interest in reopening wounds or wasting time on sentimentality. However, there were also those who, although cautious, accompanied me in that inquiry because we knew something vibrant and urgent lingered in the air. Traditional justice was not enough when life stories refused to be reduced to a file. In that process, I interviewed psychologists, social workers, and people from the community where the accused had lived most of his life. It was an uncomfortable journey, sometimes discouraging, but also revealing. Nothing was black or white, and every voice added a new nuance that challenged simplistic penal codes. The deeper I dug, the more I understood that story of pain and resistance. I discovered that the accused had been a victim of parental abandonment, ongoing episodes of domestic violence, and social precariousness that fueled his desperate decisions. I was not seeking to justify his actions, but to understand them in their complexity. The man I had brought to trial was not a mere offender. He was the living result of a system that had failed time and again to recognize and protect his dignity. This revelation hit me with unexpected force, for as a judge, my role had always been to ensure the fair application of the law, but now I had to face a reality that demanded more, restorative justice that allowed for repair and hope. As I continued progressing, an unexpected twist arose. An official report, unrelated to the main judicial process, pointed out irregularities in police intervention during the case. Minor details, apparently bureaucratic, but which cast doubt on the legality of certain procedures and the possibility that fundamental rights had been violated. This opened an unexpected door. Was there institutional injustice at play as well? Could a system that promised equity fall into practices that perpetuated inequalities? The revelation paralyzed me for a moment, but also reaffirmed my conviction that I had to act bravely. It was not easy to face these truths, especially when I felt the weight of years of training and fixed protocols. But the possibility that justice was being denied due to institutional failings and errors pushed me to redouble my efforts. I implemented a thorough review of the case with an interdisciplinary team, caring for every detail to build a mechanism that not only corrected those flaws, but helped set a precedent. It was hard work and often lonely because not everyone shared that level of commitment or openness. In the shadows, I felt the murmur of criticism and misunderstanding, but also the strength of someone who knows they are doing what is right. Alongside this structural review, the accused reality began to change. Thanks to the links we established with support organizations, he gained access to rehabilitation and reintegration programs that offered him a real chance, something he had never had before. Seeing how small gestures, like a therapy session, a skills workshop, or simply a word of encouragement, began to transform his attitude was a balm for that consciousness that seemed wounded and worn out. Justice was not only paper and punishment, it could be hope and rebuilding. However, the path was not all roses. There were social resistances and suspicions that delayed the process, and I myself had to bear the frustration of knowing that such a complex system does not change overnight. At that point, I encountered one of the harshest lessons. Justice must not only achieve immediate results, but also build bridges that endure. I knew that true transformation took time, patience, and a deep empathy that had to transcend the courtroom and involve the entire community. I began promoting dialogue tables among different actors, family, neighbors, experts, so the case would not be just an isolated anecdote but a driver of collective change. Active participation, although sometimes tense, created new spaces for silenced voices to be heard. And that, to me, was as important as any sentence handed down. As those months passed, my own perspective slowly transformed, but with irreversible intensity. I began to question not only how I framed my rulings, but the very function of justice in our society. Shouldn't it be a living system, breathing with human needs and complexities instead of being confined to formalism? This reflection led me to seek new paradigms in other parts of the world where restorative and community justice offered different, more comprehensive answers. I brought those ideas to the court, began sharing them, opening debates, and promoting small pilot changes to show that another way was possible. Nonetheless, the tension never disappeared. I often felt the weight of tradition, institutional pressure, and prejudices that slowed any attempt at change. My personal life also suffered the consequences. Friends, family, colleagues, some did not understand why I exposed myself like that, why I was not content to be just another judge in the system. That loneliness added a dark shade to my internal struggle, but also strengthened a conviction. The battle for a more humane and just justice could not be won without courage or sacrifice. It was after many months that I received the accused's unexpected visit, already in an active process of personal and social recovery. His gaze that time was not the same I had seen in the courtroom. There was something in it I could not exactly describe, dignity, perhaps, or a faint ray of hope. I did not know if his words could change everything, but hearing him tell me his story directly, without intermediaries or judgments, was a moment of absolute truth. He spoke of mistakes, but also dreams and regrets. Of how the sentence had been a hard blow, but also an opportunity to reconsider life. That encounter, simple but powerful, reaffirmed for me that justice should be that bridge between who we were and who we can become. However, that story did not end with me or with that sentence. As I moved forward, I understood that every case I faced would have that human component that challenged the very essence of my role. For me, the law was and always would be the essential guide, but justice had to be built every day, with empathy, courage, and humanity. The process of accompaniment, review, and dialogue we started with that case became a pilot model that began inspiring other courts and various parts of the country, sowing the slow but steady seed of a necessary cultural change. On this path, I also learned to recognize my own limits, to accept that I could not always resolve all injustices nor heal all wounds. But I understood that making a constant effort to listen, to investigate beyond the obvious, and to question the rigidity of an imperfect system was itself an act of justice. The true sentence was not the one I had issued on paper, but the commitment I made to make justice something alive, sensitive, and, above all, human. Now, whenever I encounter a case that seems simple, that promises to be another routine procedure, my heart and mind prepare to walk that delicate balance. I know the law must be upheld, yes, but I also know that behind every file there are stories that need to be heard, looked at with compassion, understood in their complexity. Because the justice I have learned to administer is not the one that only punishes, but the one that accompanies, restores, and transforms. And as I write these words, I think of how much remains to be done, how much we still need to understand and change. But also of the strength each of us has to make a difference, even if it seems small or invisible. In that certainty, I hold every morning when I put on my robe, with steady eyes and an open heart, ready to face cases that, like that one, will challenge me not to settle for what is easy or for what is correct only on paper. Because in the end, justice, true justice, is inevitably imperfect, human, and called to be better every day. Perhaps that was the most painful sentence I ever handed down, but also the most honest, the one that revolutionized me and forever changed how I understand my work and my commitment to the people behind every case. And although one can never say justice is complete, I know that case was a valuable step in the pursuit of a justice worthy of being called by that name. True justice, with capital letters, alive, and with soul. The thorough review of the case was neither a linear nor a comfortable process. Each new piece of information that emerged had the power to alter the landscape I had until then considered fixed and unchangeable. One morning, while going over some old reports with a member of the interdisciplinary team, we came across a forgotten letter, hidden among documents that had never been valued. It was a written complaint, penned by an anonymous neighbor, recounting episodes of child abuse and neglect toward the accused when he was a child. Beyond the content itself, what struck me was how that anonymous voice had been trapped in time, with no one taking it into account or acting accordingly. That letter represented, in a way, the silent ghost of a chain of negligence that had been accumulating, invisible to the law but devastating to the life of a human being. That revelation coincided with the arrival of a new psychological report showing a surprising evolution in the accused, but also a complex combination of traumas and resiliencies. The specialists emphasized that there was not only an individual facing the consequences of his actions, but also a survivor of circumstances which, without timely intervention, could condemn him to repeat destructive cycles. That struck me with the force of an undeniable truth. Justice could not be limited to punishment, but had to consider the possibility of healing, repairing, and rebuilding. And then, in the midst of that complexity, the possibility arose to request from the court a new evaluation of a substitute measure, focused on rehabilitation programs outside the traditional penitentiary system. I knew this proposal would not be easy for my colleagues or the public to accept, especially because we were talking about a person convicted of serious crimes, and there were those demanding a firm hand and uncompromising punishment. But inside me, something resonated strongly. That firm hand also had to have a human face. Punitive rigidity alone did not change destinies, it only prolonged wounds and created new ones. As we handled these reports, I also received discreet but present signals of support from some professionals within the system who were tired of seeing how repeated harsh sentences failed to reduce suffering or recidivism. There was a silent consensus that small changes could generate profound transformations. While planning the formal request to implement the restorative measure, resistance did not disappear. In an internal meeting, one of the senior judges harshly expressed his disagreement, accusing me of putting public safety at risk and harboring excessive sentimentality that undermined the court's authority. Those words, though harsh, made me even more aware of the weight I carried in challenging established norms and of the latent fear of transformation within the system. I felt a knot in my stomach, but did not give up. I responded sincerely, explaining that empathy was neither a break nor a weakness, but a possible engine to build genuine justice, one that protects but also accompanies. That conversation, intense and at times uncomfortable, clearly reflected what was at stake. Beyond a specific case, the very soul of justice was being debated. Meanwhile, the community began to play an unexpected role in this process. The neighbors, initially skeptical, started participating in the dialogue tables we promoted, and those meetings served to bring to light not only fears or prejudices, but also solidarities and real desires for change. It was surprising to discover that many people, despite their own frustrations, were not willing to abandon the idea that those life stories meant more than just a file. In those sessions, mothers, workers, volunteers, and other social actors shared perspectives and stories, creating bonds that had lain dormant. And in that collective fabric, I found the strength to move forward, even when the bureaucracy seemed slow and stubborn. One day I will never forget was when the accused, already a few months into rehabilitation, participated in one of those open tables. His presence caused a palpable stir. Some attendees looked at him with suspicion, others with a mixture of curiosity and hope. He spoke humbly, expressing his pain and also his genuine commitment to change. He was not just a face behind a crime, but a human being willing to take responsibility and seek redemption. Hearing his voice, his cautious but sincere words, reaffirmed to me that the risk was worth it. Of course, not everyone agreed, and the tension in the room was evident, but that moment broke barriers and opened space for renewed perspectives. However, not everything was progress. Throughout that time, I received news of unforeseen obstacles. Some social programs faced sharp budget cuts, and the resources we had negotiated proved insufficient to meet the real demand. Criticism also emerged from media sectors aiming to present the story as an example of impunity or softness in justice. These blows showed me that the struggle was not only internal within the judicial system, but extended to a cultural battle in which changing perceptions and prejudices was as complex as amending laws. I felt the physical and mental fatigue, the doubts that arose at night when silence deepened, but I found refuge in the profound meaning of my commitment. In one of those moments of uncertainty, I received an unexpected call. It was an old mentor, a retired judge with whom I had shared passionate debates years earlier. He told me, in a warm yet firm voice, that he had followed the case closely and that my pursuit of a more human justice represented a necessary leap, though difficult to understand for those clinging to old structures. He asked me not to forget that, despite visible resistances, every change begins with the courage of someone who decides to question. Those words were like a balm to my spirit, a reminder that I was not alone, and that every brave step planted seeds that, perhaps, one day would bloom into real change. The following weeks brought more unexpected twists. The court agreed to reevaluate the substitute measure, but imposed strict conditions and very short deadlines to demonstrate progress. The pressure mounted. There was great expectation around that secondary verdict. I took advantage of every day to accompany and monitor the progress, aware that although symbolic, the process could be fragile. Additionally, the lawyers on both sides intensified their arguments with new evidence and technical challenges, making it clear that this was not just a formality, but a turning point that would open debates and other possibilities for future cases. I felt the court become a theater of tensions where not only an individual was judged, but an entire conception of justice. In that climate, I maintained constant meetings with the accused, who became for me a living testimony of hope and vulnerability. Each conversation showed me new facets, his fears, internal struggle, postponed dreams, and renewed strength to face them. In one of those encounters, he confessed in a low voice that justice had not only given him punishment, but also the chance to reconnect with himself, to begin building something that until then had been denied to him. He gave me a silence loaded with meaning and words I will never forget. "Judge, you gave me more than a sentence. You gave me a second chance. I know it's not easy for me or for you, but I want you to know it's a path worth walking." That phrase settled into my soul and pushed me to continue despite everything. The day of the appeal hearing for the substitute measure arrived. The courtroom was full, not only of lawyers and judges, but also of representatives from social organizations, community members, and some attentive media. Every word, every argument seemed to resonate in an atmosphere charged with intensity. The debates were lengthy, at times tense, with opposing stances and deep reflections. At moments I felt that the room was not only judging a case, but held within its walls the possibility of drawing a new map for justice. I observed my colleagues, those who had questioned and doubted, and detected glimpses of doubt and humanity in their eyes, as if they too were confronting the same internal struggle I had carried for months. The ruling was complex. The court decided to grant the measure with some modifications and strict control mechanisms. It was not a resounding or absolute victory, but it represented an important step toward a justice that seeks more than punishment. I felt relieved, yes, but also aware that this only opened a door. The path was still long, and transformation demanded persistence. I left the courtroom with bittersweet feelings, certain that this battle was just one piece of a larger and more complex puzzle. However, that day I confirmed to myself that justice has something of daily construction, of patient and resilient labor, that does not end with a ruling but begins with it. In the following weeks, the case's impact continued to grow. Several judicial entities and external organizations requested to learn about the pilot model we had developed, and gradually, spaces for debate arose at the state level on how to incorporate restorative justice into the penal system. It was not an easy task, but the seeds had been planted and were beginning to sprout. I myself received invitations to share this experience at conferences and seminars, and at each opportunity, I emphasized the importance of always looking beyond the files, remembering that justice without humanity is an empty shell. But despite these visible advances, I also recognized that obstacles remained and that the struggle must continue. I recall a conversation I had with a social activist who participated from the beginning in the dialogue tables. He said something that stuck in my memory. "Angela, your sentence was painful, but what you have done since then is the real act of justice. You not only condemned, but opened paths for justice to be a light. What is not seen on paper but is in lives." Those words moved me deeply because they revealed that behind every verdict and protocol there is a larger and more complex truth. Justice is a living, imperfect process, in constant search, and that is what gives it meaning. As the case and its impact expanded, my perception of my own role changed. Articulating the law with human justice was not an easy or popular path, but I had discovered in that tension an inexhaustible source of learning and renewal. I recalled long nights in my office, reviewing files and thinking about how each inner world demanded to be heard. I understood that the true challenge was not to punish or acquit, but to re-signify what we understand by justice, integrating the knowledge of pain, hope, and possibility for change. It was not a path of certainties, but of constant questions and brave decisions. And although, in the years that followed, I faced new cases that would challenge those principles, I always returned to that sentence, to that process, as a beacon that guided me. Justice, I learned, is not a destination but a journey, a moving picture where every brushstroke represents an effort to balance law with humanity. And that effort, as imperfect as it may be, is as necessary as it is valuable. Because in the end, what dictates the gravity of a sentence is not only the words on paper, but the real impact on lives, the possibility of repairing and building something that transcends pain. Perhaps I will never achieve perfect justice, but I can aspire to sincere justice, open to transformation, capable of recognizing its own fragility and strength. That has been, and continues to be, my most painful sentence, but also the most honest and meaningful. My commitment now is not only with the law, but with the life that beats behind each case, with that complex and sometimes fragile humanity that constantly invites us to reinvent what it means to do justice. In that search, I find myself, day after day, with hope intact and the deep conviction that justice, imperfect but vital, can be a seed that transforms not only individual destinies, but also the very fabric of our society. The days following the hearing brought with them a strange mixture of contained hopes and fears. The substitute measure, with all its controls and demands, was beginning to unfold, but each step felt like walking on a tightrope, where balance was fragile and any stumble could topple everything built. The community, although mostly supportive of the initiative, also showed limited patience. They wanted quick, tangible results, something that would prove to them that betting on rehabilitation and not just punishment was worthwhile. That external pressure, bordering on impatience at times, added to the internal weight, that dark corner where uncertainty and self-criticism intertwined in almost whispered voices. Had I done the right thing? Would it be enough? Or was I being naive? I clearly remember one afternoon when, after a meeting in the office, I stayed gazing at the city from the courthouse window. The sun was slowly setting, tinting the buildings orange, and in that moment I felt a responsibility on my shoulders that went beyond the legal. That look out the window became a moment of deep reflection. The justice I sought needed not only to exist in rulings and paperwork, but in the real transformation of lives, in the reconstruction of bonds, in weaving new possibilities. And yet, this path was neither linear nor predictable. It was a route full of invisible twists, where every small step could be light or shadow, depending on the gaze upon it. I faced that complexity constantly. Weeks went by, and the defendant, whom we will now call Ethan to preserve his anonymity, continued his rehabilitation process. It was not progress without setbacks. There were days when his resistance seemed insurmountable, when the ghosts of the past and the pressure of the present dragged him into moments of discouragement. On one occasion, during a group session, Ethan broke down in tears, confessing with a mix of anger and sadness how much he had felt that the whole world had abandoned him, that justice had closed doors on him, and that society only saw his mistakes, not his struggle to change. It was a moment of high tension for everyone present, but also a turning point. That vulnerability exposed with sincerity opened something within the group, a space for empathy, for understanding, for accepting that the path to redemption was not a straight line but a rugged terrain with falls and rises. Meanwhile, in the court, debates about the effectiveness and appropriateness of the measure kept a flame alive. Critical voices did not subside and, in some cases, grew louder. A significant sector of the press began publishing alarming articles, insinuating that Atlanta's judicial system was bending the law before crime. Media pressure turned into a pressure cooker, and at times it seemed the entire initiative could collapse under the power of fear-driven discourse. In those moments, the private messages of support I received from colleagues who did not dare to publicly express their backing became an indispensable refuge. These communications reminded me that the battle for a more humane justice was not lonely. It was a network with invisible threads of silent resistance. But the real test came after 4 months, when the intermediate evaluation of the rehabilitation program had to be presented before the court. There was much at stake. If the reports showed substantial progress, the measure could be consolidated and expanded. If not, the defendant could return to the traditional penitentiary system and, with it, the idea that harsh punishment was irreplaceable. Tension increased in the days prior to the session. My team and I carefully reviewed every piece of data, every testimony, seeking not only objective evidence, but also signs of personal transformation. It was one night, during a late review, that one specific report caught my attention, a psychological report signed by the Rehabilitation Program Coordinator, revealing not only behavioral improvements, but a substantial change in Ethan's self-perception and his skills in managing emotions and conflicts. The words used spoke of hope. Ethan has found within himself a space of resilience he himself did not know. His progress is not linear, but it is authentic and sustainable. That reading took me back to all the months of attentive listening, to the looks exchanged at the dialogue tables, and to the silences that sometimes spoke louder than any word. At the hearing, the atmosphere was charged. I felt the gaze of many, those expecting to justify their skepticism, others holding a quiet faith in the process, community members who saw in this opportunity a real chance to break a cycle of pain. The legal arguments were presented rigorously, but to me, those words were more than procedures. They were the continuation of a human story woven with successes, stumbles, and bravery. The court decided to maintain the substitute measure, supported by a monitoring committee that would guarantee its transparency and seriousness. The decision was not an easy victory nor a unanimous applause, but the outcome of a complex negotiation, a passionate commitment. I left the room feeling that we had made progress, though aware that the road was still long and full of challenges ahead. The following months brought deep lessons. Because beyond the individual case, the initiative revealed the cracks of a system still struggling to integrate humanity into its mechanisms. Social programs, despite budgetary limitations, proved that investing in recovery was possible and necessary. The community continued to be a key actor, with those meetings where words and dialogue turned into bridges of understanding and, sometimes, catalysts for unexpected social changes. It was also during that time that I understood that justice, to be true, had to make room for repairing social wounds, those that do not appear in files. And that understanding led me to promote proposals to expand the reach of restorative justice, seeking to involve not only individuals, but entire collectives affected by marginalization and exclusion. Amid all this, there was an episode that marked my commitment forever. It happened during a community forum, when a woman, with a trembling but firm voice, approached me. She was the mother of one of the neighbors who had sent that anonymous letter years before. She told me she had never imagined that her silent gesture could resonate in such a significant ruling. She spoke of years of struggle, of pride in seeing Ethan's progress, and of the accumulated sadness caused by the initial indifference of a system that did not listen. Her words were a brutal and beautiful reminder at the same time. Justice begins with listening to silenced voices, with the courage to recognize that behind every act there are stories crying out to be seen. That night, returning home, I felt that what we had done not only transformed a life, but also wove the possibility of a different future, where justice is built from empathy and collective participation. The pressure remained a constant companion, with veiled threats, public criticism, and the weight of scrutiny. However, in that process I discovered the strength of the collective and the importance of not giving up. I was accompanied by women and men with diverse stories, all united by a firm desire to change not only laws but lives. The experience that had started as a professional challenge had become a personal mission, a tireless quest to make justice something alive and transformative. I understood that no measure would be perfect or definitive, that the real work lay in constant review, open dialogue, and the humility to accept mistakes and learn from them. That certainty began to shape my way of judging, turning each case into an invitation to go beyond the legal text and delve into the human complexity. Over time, the fruits of that experience began to bloom in other places. Support networks were formed, pilot programs in different cities, and perhaps most importantly, a growing awareness of the need to humanize justice. It was not the end of the battle, but a milestone that reconfigured expectations and opened new paths for those who, like Ethan, needed more than sentences, a real opportunity to rebuild their story. The narration of that process showed me that, although the law is fundamental, it is insufficient if it does not embrace the human face behind every file. And that lesson accompanies me every day, guiding my decisions and nurturing a deep conviction that justice, to be just, must be able to look with compassion and act with courage. Now, when I look back at that ruling, I see it with different eyes. It is no longer just a judgment, but a story of transformation, struggle, and hope. I continue facing tough, complex cases, some where the law demands severe punishment and society calls for a hard hand. But always, deep inside, there is that flame lit reminding me that justice is not static, that it cannot be limited to applying rules without questioning them, but must reinvent itself to respond to the dignity of each person. My experience with Ethan and everything around it made me understand that the real difficulty is not in issuing sentences, but in sustaining humanity in each one. That is the challenge, the living tension that defines my work and commitment. I don't know if we will ever achieve perfect justice. Perhaps that utopia is reserved for other worlds. But what I do know is that every step toward a more humane justice is worth it, even if it involves pain, resistance, and sacrifice. Because a society that does not seek to repair, that does not allow hope or change, is doomed to repeat its mistakes. And that idea is what drives me to keep learning, to keep questioning, to keep striving for our laws to reflect, even imperfectly, the compassion and dignity we all deserve. It is a difficult path, perhaps the hardest of all, but also the deepest and most necessary for justice to be something alive and transformative. Ultimately, the greatest lesson I learned from that process is not in the ruling itself, but in the movement it generated, in the lives it touched, and in the seed it planted for broader change. Because at the end of the day, true justice is not that which coldly summarizes a sentence, but the one that opens doors, transforms stories, and lights hope, even when all seems lost. And that, beyond any rule or regulation, is what connects us to the human essence and invites us to keep dreaming of a world where law and justice embrace each other in a true act of commitment to life. Despite the favorable decision, everyday reality kept striking with its relentless rhythm. Each morning was a silent reminder that justice was not defined solely in the grand scenes of the courtroom, but in the small gestures that didn't always have witnesses or applause. Ethan, although he had found that spark of resilience, continued to face the shadow of his past decisions, the judgment of those who still looked upon him with distrust and resentment. Encounters on the streets, evasive looks, conversations that abruptly stopped when his name was mentioned, all these were invisible wounds that the legal system could not close with a stamp or a ruling. I often found myself thinking about that thin line separating the law from the social fabric, about how a verdict can open a door but does not guarantee that the door will be welcomed with open arms. That understanding began to seep into each of my subsequent decisions, reminding me that behind every case there was a web of intertwined lives, with pains and hopes that escaped any legal formulation. There was a moment, weeks after the intermediate hearing, that brutally exemplified this complexity. One rainy night, I received an unexpected call. It was Ethan. His voice, heavy with difficulty and anxiety, conveyed an urgency that put me on alert. He had experienced a momentary relapse, an impulsive episode that had jeopardized his process and the trust that had been so hard to build. I heard him pause, breathe unevenly, and say that he felt all the effort could vanish in an instant. It was not a call that could be answered with cliches or legal formulas. Those words pierced me. I spoke to him from humanity, reminding him that the path forward is not always linear, that mistakes do not define everything. It was one of those moments when justice transcends the paper and becomes a commitment of life, a bridge built with listening and closeness. The next morning, I carried that episode with me to the office. The weight of responsibility mingled with renewed determination. I had learned that true justice does not only look at the precise moment, but remains attentive to the entire process, to the falls and to the decisions to get back up. We convened an interdisciplinary team, not just to assess the incident, but to strengthen support. Psychologists, social workers, defenders, and community members joined forces in a coordinated effort. It was not merely a protocol, but a way to remember that reintegration is a comprehensive process that requires more than rules, demanding genuine commitment to the person and their environment. That silent and patient work became part of my routine, a reminder that justice was much more than sentences, it was a living act. Meanwhile, media criticism did not cease. The fiercest attacks came from those demanding immediate answers and harsh punishments, incapable of hearing that change takes time and that restorative justice is not a guarantee, but a bet. I particularly recall an article with a harsh headline containing alarming claims, questioning my impartiality and the scope of the judicial system. Media pressure felt like a cold wind, an attempt to freeze all progress under layers of skepticism and fear. But amid that storm, unexpected messages also arrived, anonymous letters from people who, from their own experiences, recognized the value of change. Stories from those who had gone through similar processes and saw in this initiative a hope, a beacon in the darkness. Those words made me understand that the battle was not between law and humanity, but between different views of what it really means to do justice. The following weeks showed that neither external pressure nor isolated relapses could stop the process, but also that no victory would be definitive in such fragile terrain. There were days when Ethan came to the sessions with a shy smile, sharing small achievements, and others when disillusionment enveloped him, threatening to extinguish that light that we worked so hard to keep alive. Each of those days was a lesson in patience and humility. At a community meeting, I heard a neighbor express that although she still had doubts, she was beginning to see something real and tangible in Ethan's transformation. Her words announced that restorative justice not only impacts the accused, but slowly weaves new possibilities into the community. That idea resonated deeply with me. Justice is not limited to repairing a specific harm, but can sow changes that affect an entire social network. For my part, I began revisiting previous cases with a new perspective. I wondered how many times I had lost sight of the person behind the file, how many decisions had been made exclusively based on the law without considering the human pulse beating in every story. That experience with Ethan became a mirror forcing me to question each verdict, each sentence anew. In court deliberations, I proposed incorporating more interdisciplinary perspectives, ensuring that justice was not just the cold fact of applied rules, but a dynamic process enriched by the diversity of voices and knowledge. Sometimes I felt those changes were drops in an ocean, but I also understood that every drop counts and has the power to transform. Personally, that experience changed me deeply. I learned to face daily tension with a mix of firmness and tenderness, to listen beyond the obvious, to recognize the complexity of being a judge in a system that still does not fully know how to embrace the humanity it should protect. Those were months in which uncertainty became an inseparable companion, but also moments in which I understood that this very uncertainty opens doors to new possibilities. Justice would never be an unmovable ideal, but a living, imperfect process, full of potential to improve. And that vision was what I began to share with colleagues, students, and members of the judicial community. I knew sowing that seed was necessary, even if the path was long and rugged. What I did not expect, however, was that despite all efforts and progress, the shadow of prejudice and distrust would continue to emerge. One day, during a public session, a neighbor expressed firmly that he respected the process, but feared restorative justice was a luxury for a few, while most were still abandoned to a punitive system that only perpetuated violence. His words struck me deeply. Then I understood that the greatest challenge was not only to transform individual cases, but to build a system that recognized and addressed the deep inequalities that fed those chains of pain. Justice had to be inclusive, accessible, sensitive to diversity and to social wounds that the law alone cannot heal. It was in that reflection that I realized my role was not only to issue sentences, but also to be a voice that promoted structural changes, that encouraged justice to not be afraid to look at its own limitations and dare to dream of a different future. It was not an easy or comfortable task, but it was necessary. Because true justice reveals itself in those uncomfortable spaces, in confronting our own shadows, in the brave decision not to surrender to indifference or fear. My experience with Ethan was the beacon that lit that path, the constant reminder that behind every file there is a life that deserves to be seen, heard, and accompanied. And in the end, justice is neither an isolated act nor a finished formula. It is a continuous process, a permanent challenge that forces us to look with new eyes and to question what seems immutable. Every sentence, every decision, carries with it the possibility to open or close horizons, to sow hope or perpetuate pain. That is the deepest responsibility I accepted from that first day, with all its uncertainties and convictions. Because if I learned anything on this journey, it is that justice is not enough with the law alone. It needs something more: the courage to uphold humanity in every case, the empathy to recognize human complexity, and the perseverance to build, despite difficulties, a path where dignity is the invisible heart guiding everything. Even today, when I think of that sentence, I don't see it as a closure or a definitive victory, but as the beginning of a necessary conversation, a call not to settle for cold and distant justice, but to open ourselves to a justice that takes responsibility for its own limits and, from there, always seeks reparation, hope, and transformation. That is the legacy Ethan left me and the one I try to honor every day in my work. Because law speaks in rules, but justice speaks in humanity. And in that deeper language, that is where the future of our societies is truly at stake.